CCN.
Hello and welcome to another episode of Simplifying the Law. This is a public awareness program brought to you by the government of Guyana through the chambers of the Attorney General and Ministry of Legal Affairs to educate and enlighten you, the people, on legislation that is being enacted and laws that were already passed and are being executed. This initiative brought to you by the government was thought necessary to inform the general public of provisions within the law, not only penalties and fines or offenses which might be created by legislation, but also to inform you of your rights and your benefits that from legislation. As you're aware, the government has a very robust legislative agenda. Just this year, up to August this year, 19 pieces of acts of parliament were passed, and these are modern, complex legislation which requires some level of technical expertise to break down and to explain to the layman what they entail and contain. And therefore, through this program, we bring to you officials from the chambers of the Attorney General and Ministry of Legal Affairs. And later on, of course, we'll have persons from the private bar and even religious organizations or wherever necessary to explain legislation within specific fields or sectors. With me today, I have two persons from the chambers of the Attorney General, Miss Melissa Dolphus, Parliamentary Counsel, and Miss Rihanna Clark, Senior Legal Advisor. And today they will be helping me to go through the Foreign Judgements Reciprocal Enforcement Act 2023. Now, this is a piece of legislation that was passed in July this year. It's very new. It's a modern piece of legislation. Where we get further into what it entails, you would see that it features some 60 countries in which it may be enforced. And so this is very important for our country now, especially at this stage where we are in terms of commercial and economic development, because simply put, the reciprocal enforcement of foreign judgments refers to the local enforcement of foreign court orders as well as the foreign enforcement of local court orders. So, for example, if judgment was granted here and someone flees to another jurisdiction, and once it is contained within the legislation, then this very judgment may be enforced in that jurisdiction. So, Melissa and Rihanna, you're going to take us through this bill today, and if I may kindly give you the opportunity to introduce yourself for our viewers.
Okay. Good morning, Richard. Good morning, viewers. Thank you so much for having us today on your program. So, my name is Melissa Adolphus, attorney at law, and I'm currently employed at the Attorney General's Chambers and Ministry of Legal Affairs as a parliamentary counsel in the legislative department.
Good morning, Richard. Good morning, viewers. Yes, indeed, it is a privilege to be here this morning. My name is Rihanna Clark, Senior Legal Advisor within the Attorney General's Chambers. I'm also Liaison Officer to Ministry of Parliamentary Affairs and Governance, as well as the Ministry of Foreign Affairs.
So, if we could just get right into our discussion here today, and before we get into the Act, the 2023 Act, there was a legislation which existed prior to the passing of this, and an ordinance as well. Yes. But if you could just give us the history and overview of this act, and I'll ask Melissa.
Yes, great, Richard. Sure, no problem. So the Foreign Judgment Reciprocal Enforcement Act 2023, as you mentioned, has been enacted by Parliament recently. And so what this act operates to do is that it repeals the Foreign Judgment Reciprocal Enforcement Act of 1961. So that was the old regime that governed this area of law. And further than that, it also seeks to make new provisions, and this is very important, new provisions for the enforcement of foreign judgments obtained in countries outside of Guyana, which accord reciprocal treatment to judgments given in Guyana, and just generally matters connected therewith. So, of course, you mentioned history. Now, I know when we were in high school, history was probably, as the young people say, chewing us up. Okay, but I'm a lover of history, and I feel that it's so important in understanding the evolution of the law, because I don't know if you had the privilege, I know you're a law student yourself, so I don't know if you had the privilege of meeting Professor Duke Pollard. I think Rihanna was taught by him, and he would often say, one of the things that I always remembered him saying is that the law is not static, it's ever evolving. And so bearing that in mind as a student and as a practicing attorney today and as a drafter, that is something that I carry with me throughout. So with that being said, it's often important to understand the historical evolution of a law so that we know how is it that we really, we're here today. So in doing so, one of the things that I really want to talk about immediately is the principle of sovereignty. Now, sovereignty generally is a country's authority to govern itself. But we may ask ourselves, so what then does this have to do with the enforcement of foreign judgments? Now, as it relates to this aspect of the law, sovereignty dictates that a foreign judgment obtained in another country does not automatically, or in the absence, of international agreement, does not automatically become operational and directly operational in another country. It's just not as simple as that. So sovereignty, though it protects dominion, if it is strictly adhered to a T, we can see that it may be something that create certain barriers to the enforcement of foreign judgments and just create certain barriers to international trade. So it is against this reasoning and reasoning at this backdrop that we have that the jurisprudence with respect to the enforcement and recognition of foreign judgment has developed. So just take us a little bit back more in time. Essentially, this area of law was governed by what we call the principle of comity of nations. It was also governed and regulated by common law, and to some extent statute. Now, the principle of comity of nations recognizes that a foreign judgment may be enforced in proceedings to the extent that those proceedings are determined to have been arrived at orderly, fairly, and not detrimental to another country. With respect to common law, which is how this area was for a long time, especially in the United Kingdom, which is where we adopted our legislation from, initially the 1961 Act that I mentioned earlier. Common law, with the common law regime, judgment creditor was able to apply for summary judgment by just presenting the foreign judgment obtained to prove that a debt was owed to him. And then there was statute law. So what happened was, over the years, we realized that, as you may know, with common law, there is not always 100% certainty with the law. So evolving from that, we realized that there was a need, or Parliament then recognized that there was a need for structure. There was a need for legal structure so as to promote security and predictability within the law to govern this area of the law. So having recognized the need for that kind of structure and that kind of security, Parliament, we saw a push towards a statutory regime to regulate this area, and so therefore Parliament decided to come up with a framework that is coherent and comprehensive and would offer predictability and procedural ease in terms of how it is, what exactly is a foreign judgment, how can I enforce a foreign judgment. So with that being said, you mentioned the judgment. I think you were alluding to essentially the ordinance you mentioned before. Now, the Judgment Extension Ordinance was the first provision in Guyana that we had in a legislative manner to regulate this area of the law. Now, this 1922 ordinance, Richard, was modeled after the I think it's the Judgment Extension Act of the United Kingdom of 1868. So that's how far back the roots of this law, that's how far back it started. So we had the 1922 ordinance, which in Guyana, it meant that the governor at the time, as he then was, if satisfied that reciprocal provision was made in another country, would be able to extend that ordinance to that country. And also, having been modeled and adopted from the United Kingdom, it also extended judgments under that ordinance to judgments obtained in the United Kingdom. So then fast forward to 1961. The ordinance became the Foreign Judgment Reciprocal Enforcement Act, which was once again modeled after the Foreign Judgment Reciprocal Enforcement Act of 1933 of England. So we continue to see a pattern where, even though we were in 1961, we were still modeling our law after a legislation that was passed in 1933 in the UK. So certainly, at that time, it was seen, when it was introduced in 1961 by the then Attorney General, it still seemed as a relatively modern piece of legislation at that time. But mind you, the issue that we would see arising with that is that the Judgment Extension Ordinance, which it developed from, made provisions for the governor to make an order, and the Judgment Extension Order is what set out a schedule of a few number of countries only that the act and the ordinance at the time would be able to extend to. And I think Trinidad and Jamaica and Barbados were just a few of the countries that were also Commonwealth countries, and at that time were also dominions of the United Kingdom. So what we realized that as a result of that, we operating until recently with the 1961 legislation, we realized that there were certain limitations that were created in the law, because it be 1961 and now it's 2023, so that's a long time, a long passage of time. So certain limitations that we observed was that, okay, for example, the 1961 legislation was limited in terms of its application. Like I said, there were just a few countries that it applied to. So you found, therefore, that if, for example, one of the countries that it did not apply to at the time was Canada, which is now being provided for. So if, for example, you obtain judgment in Canada against a judgment debtor and you would like to come to Guyana to enforce that judgment, we saw that you would be met with challenges and difficulty, and it would be somewhat impossible for you to now come and enforce that judgment here. So we also noted that, of course, and when I say we, I mean Parliament, of course, we also noted that the act was restrictive and limited in terms of the types of judgment which it dealt with. So under the old act, it significantly dealt with monetary judgments, and of course that was seen as somewhat archaic and antiquated, that at this time we're still just only making provisions for monetary judgment. And so in repealing the act, one of the things that we thought, Parliament, again, as I'm saying, when I say we, thought that was necessary is to extend that to not only monetary now, but to non-monetary, to be inclusive of non-monetary judgment. It was also limited in the sense that so just a second. It was also limited in the sense that I lost my train of thought a bit there. It was also limited in the sense that it only it did not set out clearly and in a very precise and concise manner the judgments to which the 1961 Act would apply, and also the judgments which would be excluded from that Act. So Parliament, in realizing these limitations, and coupled with the fact that, of course, we can't, like you would have alluded to, deal with this area of law without touching on the oil industry, and Guyana now being an oil-producing nation.
Yeah.
So as a result of Guyana now being declared as a result of the oil one of the fastest growing economy, we have seen that we have become somewhat more attractive in terms of investment, and so we've seen an increase in fiscal and commercial activities. So this coupled with the need to have a legislative framework which is reflective of best practices in light of the upward trajectory of the country, we realize that the government and Parliament more so realize that there is probably no better time than now to have a repeal of the old Act, to make newer provisions for the enforcement of foreign judgments. So that is essentially the history and overview. Okay.
Very elaborate there.
Yeah.
Thank you for that.
Very comprehensive.
So there was definitely a need for reform
Definitely a need for reform
during that
yes.
time period. Now, to get into the Act itself, but before we do so, could you kindly explain to us what are foreign judgments?
Yes, I know that a lot of mention has been made, even when we consider the history of the legislation to the term foreign judgments. Foreign judgments very simply refer to final decisions of courts of foreign countries that are deemed under the Act to have had jurisdiction to make that order or that judgment. And it will include both monetary and non-monetary judgments. Now, when we speak of monetary judgments, very simply, they're judgments under which a sum of money is payable. When we talk about non-monetary judgments that are enforceable under this Act, it will include judgments that not only require parties to do specific things, but may require them not to do specific things. So, for example, in terms of the judgments that will require parties to do specific things, you can have an order or a judgment ordering one of the parties to perform an obligation under a contract. So it can be an order for specific performance of a contractual obligation. It can be an order for the transfer of a specified item or specified items of property. Now, in terms of judgments that will prevent a party or will order a party not to do a specific thing, you can have orders from the court that restrict or that order the judgment debtor not to perform a task, or it prohibits the judgment debtor from performing or acting in a specified way. Now, I would have mentioned here, and even when we looked at the overview, we mentioned the term judgment debtor and judgment creditor, and it's something that will continue to arise even as we have this discussion. So I think it would be apt to define those terms. Now, when we speak of the judgment creditor, very simply, it's the person in whose favor judgment was granted. And it also includes those persons in whom rights are vested under that judgment. So those rights that they would acquire by virtue of an assignment or succession. Now, when we talk about a judgment debtor, it's the person against whom the judgment was made. But more so, it is also those persons against whom the judgment is enforceable. We're going to get into the enforcement stage, and we're going to explain that a bit more. So.
All right. And I noted that you listed judgments which may be enforceable. So if you could actually take us through now what foreign judgments are actually enforceable via this legislation.
Okay, so not all, and what we need the public to appreciate is that it's not all foreign judgments that are enforceable in Guyana. The legislation prescribes the types of foreign judgments that are going to be enforceable, and it clearly states that the foreign judgments that will be enforceable are those originating out of the countries that are listed in the schedule. And Richard, you mentioned this earlier. There are about 60 countries that are listed in the schedule, and we have Caribbean countries like Antigua, we have Barbados, we have Trinidad, but we also have countries like Australia, Canada, as my colleague mentioned, which was not previously included. Canada is mentioned, the United States is included, South Africa is included, the United Kingdom is included. So these are countries that are listed in the schedule of the Act. So these are the countries that the Act will apply to. Now, in addition to the countries that are listed in the schedule, Guyana will also enforce foreign judgments or judgments originating out of countries where there is an international obligation or an obligation under an international agreement to recognize and enforce those judgments. So quite apart from the schedule, if Guyana has an obligation under an international agreement to recognize and enforce judgments originating out of specified countries, even though they're not listed in the schedule, the Act will still apply to them. Now, what I want the public to appreciate as well is that the list that is in the schedule, or the list of countries in the schedule, is not an exhaustive list. The minister under the Act, and that is the Minister of Legal Affairs, he has the authority, or he's empowered under the Act to amend that schedule, where as time progresses, it is discovered, or he is satisfied that there are substantial provisions in foreign countries that will allow for that mutual enforcement of our judgments in their country. So as that arises, the minister will be able to amend that list to now include those countries that have enacted provisions that will allow for the mutual enforcement of our judgments, and the judgments, of course, from our courts. And so one thing that my colleague would have mentioned, and you even mentioned too, Richard, is that this entire regime functions on mutuality and reciprocity. And so in all cases, it has to be that mutual enforcement of our judgments, and we will accord similar treatment, coming back to the principle of comity.
Okay, are there specific types of foreign judgments to which the Act applies?
Yeah, certainly. So Section 4 of the Act makes provision for a range of judgments to which the Act may apply. So as I mentioned earlier, under the former Act, they just dealt significantly with monetary judgments. But what we've created now is a provision for non-monetary judgments. So the Act may apply to monetary judgments, as Rihanna would have I think you mentioned monetary judgments and defined it. Yeah, so it's self-explanatory and suggestive where money is due to a person, but just a little bit more on non-monetary judgments. So she mentioned non-monetary judgment could be in the form of maybe specific performance, or the court ordering someone to transfer property or to not do something. But non-monetary judgment may also take the form, may also emanate from civil proceedings, where a lump sum it is ordered for a lump sum of money to be provided as financial provision for maintenance for a spouse, a former spouse, a child, or a dependent. It may even emanate from criminal proceedings, where it is that an order has been made for monies to be paid as compensation for damage to the injured person. The Act also extends to arbitral proceedings and arbitral awards. So if it is that, and we know arbitration is becoming something that is a bit more prevalent around the world. We see a lot of contracts where it is that persons would prefer to use arbitration as an alternative, and as an effective alternative way of dispute resolution. So the Act makes provision for those kinds of arbitral awards, and it would recognize an arbitral award if it is under the country in force in that foreign jurisdiction. They recognize arbitral awards in the same manner as they do judgments given by superior courts in that country. It may also extend to interim payments. It may extend to judgments where it is that even if an appeal is pending against a judgment, it may still extend to judgments in those cases. And one of the things that we want to remember when we speak of judgments, and even if there is an appeal pending, that it would still be enforceable, is that the reason for that is that generally, once it is that a judgment has been given, that judgment must be seen as final and conclusive. So as, for example, it may form the defense or a counterclaim. So those are generally the types of judgments to which the Act applies.
And are there any specific judgments which are excluded from the scope of the Act?
Right. Well, naturally flowing from the fact that there are specific judgments to which it applies, there are now also specific judgments to which the Act does not apply. Now, it's an exhaustive list of acts to which judgments to which the act does not apply. So, for example, for my colleagues at the bar and just the average person, if it is that, but more so, I want to say, for my colleagues at the bar, if it is that you find that there is a foreign judgment has been given and it appears in front of you, maybe because the judgment creditor comes to you for help to find out what are the next steps to enforce this judgment. It's a situation where you may want to first of all consult with the act and see if it is that this is a judgment that it would be recognized under the scope of this act. So, as I said, it's an exhaustive list. I would encourage persons to just pick the act up and familiarize themselves with the list. But just to touch on a few of the judgments that are excluded. So the Act, for example, does not extend to or does not make provisions for cases of succession and the matters of succession and the administration of the estate of the deceased person. It does not deal with proceedings relating to guardianship of infancy. It does not deal with bankruptcy and the winding up of corporation. It does not deal with matrimonial matters where it is that periodical maintenance is ordered. So these are just a few of, I guess I want to say, the more popular ones that people may be interested in knowing about that are excluded from the Act. But of course, as I said, it's an exhaustive and comprehensive list. So there are other judgments which are essentially excluded. So it would just be for you to take the time and just go through them to familiarize yourself with some of them.
Okay, thank you. A specific part of the Act which I would wish to touch on is in relation to the jurisdiction of the original court, and this term here is in need of interpretation, right? So I would just pose a question to you now. What is meant by the term original court, and when is the original court deemed to have jurisdiction under the Act?
Okay, so pursuant to the interpretive section of the Act, the original court is essentially the court which gives the judgment, in a foreign country. So that is what it essentially is, the original court. And of course, the issue of jurisdiction, as you may well know and my colleague would know, it is an issue which transcends every area of law. So it comes as no surprise that Parliament, of course, would have contemplated and make provisions for jurisdiction within the Act. So, of course, when you're trying to have a judgment recognized or registered and enforced in Guyana, one of the things that you must ask yourself, did the court that gave the judgment, the foreign judgment, have the jurisdiction to so do? Right? And so in examining that, once again, in the interest of time, I won't necessarily be able to go through all the grounds that would furnish a court with jurisdiction. But just to mention a few, so Section 6 sets out the grounds that would furnish a court with jurisdiction. And a court may deem to have jurisdiction where it is that the judgment debtor agrees to submit to the jurisdiction of that court, or where it is that the judgment debtor appears voluntary in those proceedings, or if it is that the judgment debtor, if it, in the case of an incorporated body, has its central management located in that country and the business itself is located in that country. Those are some instances where it is that the court would be deemed to have jurisdiction. However, what is important to note is that I mentioned, of course, that the court may be deemed to have jurisdiction if a person voluntarily appears and submits to that jurisdiction of the court in the proceedings. However, what it would be interesting to note is that there are instances where a person may voluntarily appear, but there are conditions under which they are appearing. So the conditions are examined in Section 6 as well. I believe it's Section 6.2. So that may be, so the court may be deemed to not have jurisdiction if it is that the person appears, but the person only appears to contest the jurisdiction of the court, or the person appears to, let's say, for example, the person appears to ask for an adjournment or a dismissal of the proceedings on the ground that they agreed that the dispute arising in the proceeding would be settled by alternative means outside of the court. So, for example, with respect to arbitration. And And this is important to note because I've actually seen cases where it is that you have a contract and the person's agreed that, hey, we're going to go ahead and settle any dispute arising out of this contract by arbitration. But in spite of having that arbitration clause there, for some reason, I don't know, a party may still move to the court. So in instance like that, the court would be deemed to not have had jurisdiction. Another instance where it is that the person may appear voluntarily, but under a condition which would be deemed to not give the court jurisdiction, is where you just appear to protect or to obtain the release of property which may have been seized. So that's that. So the original court shall not be deemed to have had jurisdiction where, for example, as well, the subject matter arising in the proceeding relates to immovable property, and that property is not within the country of the original court. So, for example, let's say it is Canada, and they're dealing with a matter with respect to immovable property in the proceedings, but the land or the home, the property that is not located in Canada, the court in Canada would not have the jurisdiction or not be deemed to have the jurisdiction to make a pronouncement and make a judgment with respect to that property. So those are just general instances where the court would not be deemed to have jurisdiction.
Okay, thank you for that. Rihanna, if we could just come to you real quick. How does a foreign judgment become enforceable here in Guyana? Is there a procedure which the legislation sets out to be followed? If you could just take us through that process.
Okay, thank you so much for that question, Richard, because I know we've done a lot of groundwork and we've laid the foundation, but I think most persons now are concerned with, okay, I have this foreign judgment, what do I do? Right. And so the first step, having obtained that foreign judgment, is to determine whether it is enforceable in Guyana. And we touched on this in our preliminary discussion. You have to look at two things, principally. You have to look at the country of origin, because as I said, not all foreign judgments are enforceable. So you have to look at the country that the judgment is originating out of, and then check it against the legislation to see whether the act applies to that judgment, or that country will be able to, the judgment originating out of that country is capable of being enforced. And then the next thing you need to do in determining whether it is capable of being enforced is that you need to look at the substance of the judgment. You look at the nature of the judgment, because as my colleague mentioned, there are certain judgments, although they may be originating from countries that are listed in the schedule, because of the nature of the judgment itself, it is not capable of enforcement in Guyana. So the first thing you need to do before you start taking any steps is to determine first and foremost whether that judgment is capable of being enforced. And you do so by looking at the country of origin, and you look at the nature of the judgment. Having been satisfied that it is a judgment that is capable of being enforced, you have to register it. Now, why do you register? Because the Act says so. The Act says that your foreign judgment will not be enforceable unless it is registered. It has to be registered. And so the next question then that would flow is, okay, so how do I register? And registration is done by way of application to the High Court. The Act speaks to an application being made to the High Court in accordance with our Civil Procedure Rules of 2016. Now, when we speak of an application, our Civil Procedure Rules contemplates commencing proceedings in two ways, either by way of statement of claim or by way of fixed date application. In these circumstances, the application has to be done by way of fixed date application. And that is because when you look at the civil procedure rules themselves, apart from saying how the two ways that matters can be commenced, it also prescribes that in cases where an act, in this case it would be the Foreign Judgements Reciprocal Enforcement Act, where an enactment or an act of parliament specifies that an application is to be brought to seek some remedy under the legislation, that application has to be brought by way of fixed date application with supporting affidavit. So when I'm seeking to commence the process now and register the judgment, I do it by way of application to the High Court, by way of fixed date application to the High Court, with supporting affidavit. Now, what I need the public to appreciate as well, Richard, is that it's not open-ended. You don't just make the application whenever you wake up one morning and say, well, I'm in need of some money, and I remember I had this judgment. I'll just move to Guyana and try to enforce that judgment. It's not like that. You have to take steps to enforce it, or you have to file that application within 6 years after the date of judgment of the original court, right? So you start to compute time from the moment that the judgment is given in the court of the foreign country. It will also, in cases where that judgment that was made by the foreign court or the court of the foreign country was appealed, the time will begin to run from the date of the last decision. So it won't start to run from the date that the first decision was given. If it wasn't subject to an appeal, it will start to run from that time. If it was subject to an appeal, it will start to run from the date that the last decision was given. Right? So you have to move within 6 years of the date of judgment to actually file your application. The question may be asked, can I be prevented from registering it? Right? So let's say I do satisfy the requirement. It is capable of being enforced in terms of the country of origin, in terms of the nature of the judgment, but can I still at the registration stage be denied registration? And the answer is yes. If, for example, the court finds that that judgment has already been fully satisfied, you can't seek to satisfy that judgment again. Another instance is if at the time that you're seeking to enforce that judgment, it would not have been capable of enforcement in the country of origin. So, for example, where you have a statute of limitations that prescribes the time by which you must bring enforcement proceedings for certain orders. If you were not capable of enforcing it in your country, in the country of origin, you will not be able to enforce it here in Guyana. So the legislation clearly says that you will be prevented from registering if your judgment is fully satisfied or if you would not have been capable of enforcing it in the country of origin. Now, I want to just go back a bit to the first stage where I was mentioning whether the judgment, the first step, which is to determine whether the judgment is enforceable. Because you may have a situation where, yes, you satisfy the first limb, that it's coming out of a country that is listed in the schedule or contemplated under an international agreement, but then you go to the second limb, which is to look at the nature of the judgment. Now, you may have some judgments that are blended. So you will have some judgments that have content that is enforceable, and it will have content that is unenforceable. If that arises, you will still be able to register the judgment in respect only of those provisions that are capable of being enforced. So it's not a case where if you receive a blended judgment and it has aspects that are unenforceable and it has aspects that are enforceable, that you're altogether without a relief or altogether without remedy. The court will still allow you to register those aspects that are enforceable. Now, I want to fast forward back to where we were when I was talking about, can the court deny me registration? And I mentioned one of the circumstances would be where the judgment is fully satisfied. But the question may be asked, okay, so this person is required to pay me a lump sum of money, but they've only paid me a portion of it. So I have partial satisfaction of the judgment. What happens then? Am I still able to register and seek enforcement? Yes. The court will say, yes, we notice that this judgment has been partially satisfied. There is evidence of partial satisfaction. We will allow you to register in respect only of the portion that is unsatisfied. So you don't register that entire judgment and seek to enforce that entire judgment. You're only allowed to register that portion that is unsatisfied and then move to enforcement proceedings in respect of that portion. I think something that might be of great concern to persons who are trying to enforce foreign judgments is that those foreign judgments, especially if you're dealing with monetary judgments, they're going to be in a foreign currency. So they may wonder, okay, well, what is my rate of exchange? Do I stand to lose when I try to enforce it in Guyana? What rate of exchange are they going to use? And in Guyana, when we are enforcing foreign monetary judgments, the rate of exchange that is used is the rate of exchange prevailing at the time that the original court made the order. So if it goes back 4 years, because remember, you have to do it within 6 years, if at the time you're seeking to enforce, it may be 4 years after the judgment was given, we will use the rate of exchange that prevailed 4 years ago, not the present rate of exchange. That is for a judgment that has not been satisfied at all. In the case of a judgment that has been partially satisfied, and again, we're still talking about monetary judgments, the court wants to ascertain, okay, I see that you've registered in respect of the portion that is unsatisfied. I need to ascertain how much it is in terms of Guyana currency. What they will do in terms of assessing the amount that has been satisfied, they will use the rate of exchange that prevailed at the time that that person was satisfying the judgment. So if they made a payment in let's use 2020. Let's say they made a payment in 2020. The court will look at the rate of exchange at that time and set that down. And then they will look at, let's say they made a payment in 2021. They will use that rate of exchange, and then they'll compute or calculate the two and then say, okay, when I deduct this from the total, this is how much is yet to be satisfied. So even when the court is considering what has been satisfied and trying to ascertain exactly how much you are still to get, they will use the rate of exchange at the time that the payments were made. One final thing, if you would permit me, that I think is of great concern, even when we file matters outside of the Foreign Judgements Reciprocal Enforcement Act, is money. What about the cost of the registration? Who bears the cost of the registration? And our act actually allows for the cost of that registration and enforcement proceedings to actually be added to the cost or whatever is stated in the foreign judgment. So in addition to getting what is substantively within that foreign judgment, you will also be able to recover the cost of having to move to our courts and initiate these proceedings.
Okay. Well, thank you for that elaborate explanation there. And I know you mentioned a critical element within that process there is the registration of the judgment. So if you could briefly explain to us the effect of a registered judgment.
Okay, so very briefly, and I guess what is most important is that once you register, you can proceed. Once you register that foreign judgment, you can proceed right away to enforcement. Right. Sorry, well, not right away, because of course there are provisions within the Act that allows the judgment debtor to set aside that registration. But once you register, one of the entitlements under the law is that you are now you are permitted to move to enforcement. So it has the force of law, and apart from that, it begins to carry interest. Okay. So you will also be able to recover an additional sum of money once that judgment is registered.
Right, but importantly, after a foreign judgment is registered against a party in the scheme of things, can that party then move to set it aside, that registration?
Yes, interesting enough, and that's a very important question, because to a significant extent, the Act deals with foreign judgments given in favor of the judgment creditor. So of course, if it is that you're a judgment debtor, and that being that you're the person against which a foreign judgment was made, of course you're wondering, hey, do I have any relief under the Act? Is there anything that I can do? Do I just have to take it that you're registering this judgment and there's nothing that I can do about it? And of course, the answer to that would be no. It's not a situation where you can't do anything. The law makes provision for instances where and grounds where you as a judgment debtor may apply to the court to have that judgment set aside. Now, as I mentioned this earlier with respect to some of the other sections, but in the interest of time, once again, it is a very exhaustive and comprehensive list of grounds on which a judgment debtor can apply to the court to seek to have the recognition and registration of a foreign judgment be set aside. But there are a few that I really want to just touch on, just mention generally. So a judgment debtor may move to the court to have the judgment set aside on the ground that the foreign judgment was registered in contravention. And just in case I may have glossed over it and not made it very clear for everyone, is that you're really dealing with the setting aside of the registration of the judgment and not necessarily set aside the judgment on its merits or substantively. So one of the some of the grounds include, well, one, if it's a foreign judgment that was made in contravention of the Act, if it is a foreign judgment that was obtained by fraud, if it is a foreign judgment where it is that you can prove as a judgment debtor that, hey, this court didn't have the jurisdiction to entertain this matter, it didn't have the jurisdiction to make a judgment or pronouncement, you can move on that ground to have the judgment set aside. It can be a situation where it is that you, being the judgment debtor in the proceedings, was not duly served with notice of the proceedings according to the rules of the original court, or in a situation where even if you were duly served, it is a situation where you were not served in with sufficient notice and a sufficient time to allow you to properly defend yourself in those proceedings. And these things can happen because persons often like to find loopholes in the law, and we say, oh, yeah, I followed the rules, I served this person, but then you may have duly served the person, but if it is that the person only received notice of this proceedings the day before, how then can you, properly defend yourself? You're going to be calling an attorney late at night. How can you properly be able to make fair representations on your behalf? So these are all things that the court would consider and look to see if it is that they're willing to exercise that discretion, all things considered, to set aside a judgment. And further than that, other instances where it is that the registering court may wish to grant you an order to set aside the registration of the judgment are instances where it is that an appeal may be pending against the foreign judgment, or if it is that you as the judgment debtor can prove that you are entitled to this appeal and you actually intend to act on that and actually appeal. appeal. Those are instances where it is that the registering court may be able to set aside a foreign judgment. So yeah, you don't have to just take it lying down.
Okay. And we've spoken a lot about foreign judgments, and one of the critical things which I would like to get down to is application to Guyana here, you know. So if you could tell us, what is the effect of the recognition of foreign judgments here in Guyana, and are there instances where recognition may be refused?
Okay, Richard, if you would permit me, I just want to go back. I know we talked about what happens, what are the stages. It's actually a three-stage process, and I know we're strapped for time, but I just need to get the public to know the three stages. The first, of course, you have to determine whether the judgment is capable of being enforced. The second step is registration, but the third step, I suppose, which is the most important, would be moving to enforce it. And so you bring enforcement proceedings under the civil procedure rules, and so you can have various methods of enforcement depending on the type of order. So the type of enforcement order that you're going to seek will depend on the type of foreign judgment that you have. So you can have, for example, garnishment proceedings where you're trying to enforce a monetary judgment, or you can have a writ of delivery where you're trying to secure the transfer of personal property. So just 3 steps. You determine whether the judgment is capable of enforcement, you register, and then you move to start enforcement proceedings. Now, in terms of the question you asked, recognition of foreign judgments, and I think this is very important because it shows how comprehensive our legislation is, because we've spoken extensively about the enforcement of the foreign judgment, but our legislation also contemplates recognition of the enforcement of the foreign judgment. And so recognition is different from enforcement. With enforcement, you have to register. If you're seeking recognition, or you want the court to recognize that foreign judgment, there's no need for the registration of that judgment. Why is that? Simply because you're asking the court to take notice of the fact that a court has already pronounced on a specific issue. So you will find that, let's say proceedings are commenced here in Guyana, a party can use that foreign judgment as a defense to say, well, a court of having jurisdiction has already pronounced on this issue and there's a judgment of it on it. And so our court will recognize that judgment. They're not seeking to enforce it, but they're seeking to use it as a defense against relitigation of the same issue. So recognition of foreign judgments basically speaks of our court accepting that a court has already pronounced on that issue, issuing a judgment that is substantially in the same terms, and of course that judgment remains as binding between the parties, right? So it's really being used as a defense more so than trying to enforce it. In terms of whether the court can refuse recognition of a foreign judgment, yes. For example, coming right back to what my colleague said, if it is found that the judgment was arrived at in breach of the rules of natural justice and procedural fairness, meaning that the other side wasn't heard when they ought to have duly been heard, or if it is a situation where the parties decided to commence proceedings on the same subject matter, so the same parties commence proceedings concerning the same subject matter in Guyana, and then they move to, let's say, Trinidad and commence proceedings concerning the same subject matter, and it's just a case that Trinidad's court ruled before Guyana's court, but it was really initiated in Guyana first. That's a situation where the court won't give recognition because it was a matter that was pending before our courts long before it was initiated in Trinidad and a judgment was made. Apart from that, if the judgment in itself is inconsistent with public policy, it would not be recognized.
Okay, thank you. And there's one final question here which I wish to ask, and there's a rules of court provision contained within the Act. So if you could take us through the importance of that there.
Okay, so essentially there's provision for rules of court in the Act, as you mentioned, and the reason for this is that it enables the High Court to make rules to better give effect to the provisions of the Act. So much like the civil procedure rules and the family rules, it helps the Act to function better. And some of the things that may be provided for under the rules of court made by the High Court would be matters with respect to, for example, the setting aside of judgment, the time that you may have to set aside a judgment. They may make rules with respect to matters that needs to be proved in terms of registration. They may make rules with respect to notice and what time and the process that should be followed in giving notice. So these are just general areas that the High Court may make rules with respect to, but of course the main objective of that is to help the person to better be able to procedurally enforce the Act and to better carry out the provisions of the Act. So that is that is generally it.
I think we've had quite a comprehensive program today. Thank you both for being here and taking us through this legislation here. I know this is a very critical piece of legislation, especially where our country is headed and where we are right now in terms of being one of the fastest growing economies in the world. And this here is definitely going to give a spike to investor confidence, especially foreign investors who are coming here to invest and know that we have this type of legislation which allows our country to function on that bilateral or multilateral level internationally. So this here is definitely a piece of revolutionary legislation, and the legislation itself is much alive, like you've mentioned, the rules of court which a court can make and the powers of the minister to amend the schedule. So it's not set in stone, it's not stringent to that extent. It can be expanded to take into account a whole host of things. So once again, thank you both for being here with me today to go through this act. I know we've had quite a comprehensive discussion, and it was a packed program.
It was.
So, as I've mentioned at the beginning of the program, this here is an initiative by the government of Guyana through the Attorney General Chambers to educate you, the public, on laws that are being passed and enacted for your benefit, of course, so that you may be quite up to date with all that is going on, because given the government's robust legislative agenda, you need to be kept up to date with what is happening, especially penalties and your rights. And as the Honorable Attorney General would most often say, ignorance of the law is no excuse. So this program here is for you, the public, and for your benefit. Until next time, see you again. I'm your host, Richard Bailey.